division is now a kind of an independent division of compliance and administration. That kind of change happened in the the fiscal year starting beginning of July. So when you see communication come through from this group, you'll see it reference the Division of Compliance and Administration, or DCA. That division is currently being led by Justin Robinson. He's on the phone right now. He's the executive administrator. He started with the division in January and has been leading the team through this pandemic and all of the challenges that it has brought. So he is still getting his feet under him in his new position, not even 6 months in yet. So just so you all are all aware of that. Next, Jake is on the call too, and he's been going to be assisting with the presentation. He's kind of your main contact in terms of compliance relating to your rental properties. Jake came on the team towards the middle of April and is getting up to speed with his new job role. And then we also have a new staff person, Corey, who's also on the line too. You may be interfacing with him as well at some point. Corey just started this week. I'm looking at my calendar, remembering what day it is, but yes, this week. So so there's been a lot of changes, a lot of new faces here. And for those of you that don't know me, my name is Stephanie Burdick, and I'm a consultant that works with the Office of Housing. Duties are relating to the Division of Compliance and Administration. So you might see my name on a lot of communication pieces, or I might be a contact for certain things that you're working on. So just kind of some housekeeping things. I think we're all kind of getting used to doing virtual trainings and virtual meetings. I don't know if you're familiar with this WebEx, but just so you're aware, your computer will be muted, and you are welcome to keep your video on. I would recommend keeping it just so I think it's a little bit easier on you guys as a viewer to keep your video off. If you have questions, please use the chat feature, and then you can send a message directly to Justin Robinson. He's going to be kind of the moderator during all of this. You can write your question into that, and then Justin can ask the question to us when we get there. Or you could just say, I have a question. And then when we get to the question section, he will unmute you and you can answer your question at that time. We have a lot of breaks within the presentation to ask questions. Presentation. And then also, if we have time at the end, we'll have time to answer your questions then. So
Stephanie, I also wanted to make note that we are recording this session, so we can add that to the website later as well.
Yes, thank you. So today, our agenda that we'll be going over, we're going to talk about briefly about ongoing compliance requirements. We'll spend a lot of time talking about the Federal CARES Act and how it's relates to your property. We'll talk about the annual compliance reporting that's required of your property, what that's going to look like this year, and then also have time for questions. And like I just said, we have plenty of time for questions throughout the presentation. So ongoing compliance, why is there ongoing compliance? And in very brief terms, it's because HUD requires it, and HUD requires it of Louisville Metro government to ensure when they give out funding to projects like yours, that they ensure that Louisville Metro government in turn ensures that your project is going to be compliant for a period of time. That period of time is called the period of affordability, or the POA. And that is the time that your property has to remain affordable and is subject to the rules and regulations that are outlined within the home regulations, and then also within your property's regulatory agreement and other legal documents. So the main guiding document for the Division of Compliance and Administration in terms of how long your property, your specific property, will have to remain compliant with the regulations is within its regulatory agreement. That's a legal document. It is recorded. And if you don't have copies of any of your loan documents, whether that's a mortgage, a note, your funding agreement or loan agreement, or your regulatory agreement, please contact the office and we can get those things to you. Like I said, those are the documents that guide the work that the division does. And so we want to make sure that you have access to those as well. So each project is going to have its own commitments that are made when the project was initially funded. During the period of affordability, the division has to make sure that each project is fulfilling these commitments. So there's a number of type of commitments that are out there. Number of home assisted units, how many are considered high or low home units. If they're specific bedrooms, so you might have, I have to have 6 one-bedroom high home units and 3 two-bedroom low home units. Some projects will go into that detail. You are required to have compliance with tenant rent and income limits, property standards, lease requirements, etc. So there's a lot of commitments that are out there that we're looking for. And if you're new to the field, new to property management or ownership, again, I would encourage you to read those documents on your property, because again, those are going to be kind of the guide for you all on what you are required to do. And a lot of times we will see disconnect sometimes between the people that develop the property to those that own or manage the property, not always knowing what is required in terms of ongoing compliance. So again, knowing what the envisionment of the property was when it was developed is most certainly beneficial for you all as you manage it or own it. So normally during our time together when we've been doing these annual training presentations, is we spend a lot of time on these variety of different compliance requirements. Unfortunately, given all of the extenuating circumstances that we have right now, we don't have the time to go through all of them. So there has been a compliance guide that has been put out, that is being put out by the department to provide you all with some information on just generalization about home basics. It talks about income determinations, lease requirements, rent, utility allowances, property inspections, monitorings, and noncompliance. So It's just, again, a informational guide for you all. We will be putting it out via email for you all to have. And then I will also be up on the website as well. But again, since we didn't have the time to go over that today, a lot of that today, we wanted to make sure that you guys had something in writing to reference and work through, so that you could have that, because we didn't have a presentation for you guys to reference this year. So any questions at this point before we get into the CARES Act?
I just want to take a second to remind everyone that, if you have any questions at any other point after today, you're reading through the guide or anything like that, that's what we're here for. So don't hesitate to reach out to any of us. That's what we're here for.
Stephanie, I'm not seeing any questions in the chat bar.
Okay, perfect. All right, then we're going to get going on the next slide. All right, so the CARES Act. So the CARES Act, if you're not familiar with it, is the Coronavirus Aid, Relief, and Economic Security Act, which was signed into law in March of 2020, the end of March. And so there's a lot of things that are in that CARES Act, and as it relates to us within Louisville Metro, within the Division of Compliance and Administration, and then also with your properties. The two big things are the CARES Act eviction moratorium, and then also the CARES Act and home. So the eviction moratorium is we're going to spend a lot of bulk of our time talking about today. But essentially what that does is provide immediate protections for tenants unable to pay rent. And then with home, the CARES Act provided some flexibility to participating jurisdictions, which is Louisville Metro government, regarding home regulatory statutes. And what that has done is it just addresses the fact that there are some things that Metro is not able to do in the time period that it normally is able to do because of these large extenuating circumstances that we have. So the CARES Act eviction moratorium, who does it apply to? Well, it applies to everyone on this call. So that's why we're going over it today. There are kind of two ways that projects that have money or have funding from Louisville Metro government that are within their period of affordability fall under this moratorium. The first is that properties may have a federally backed mortgage loan as defined in the CARES Act. So almost all of you that are representing a project or property today that has that is within the period of affordability, or even potentially out of the period of affordability, that received money, federal money from Louisville Metro government, will have a federally backed mortgage as it's defined. So as a result, that's why the CARES Act eviction moratorium is applicable. Properties also can be considered, have this be applicable to them because they are a covered housing program as defined in VAWA, which is Violence Against Women Act, and home is considered a covered housing program. So if your project received home funds, which the majority of the projects that are within their period of affordability, that are within the portfolio that the Division of Compliance and Administration is monitoring, receives home. And so as a result of that, you all are, this is applicable to your property. to those couple of you that got money from a different source, then you'll have a federally backed mortgage. And so it's applicable to you all as well. So not only does it talk about how it applies based upon those, it talks about what units are also considered applicable under this eviction moratorium. So home assisted rental projects that are currently within their period of affordability. So you all are participating in this presentation today because you have projects that are within their compliance period with Louisville Metro. Again, vast majority of you received home, and so that's why, again, it's going to be applicable to your project. But what the CARES Act also does is say that even if projects are no longer in their period of affordability, but they still have a home or a CDBG loan or another federally backed mortgage type that's still secured on their property, this CARES Act eviction is also still applicable to your property. Some other things, some other areas where this eviction moratorium is applicable: homeownership projects that contain rental units that are still within the period of affordability or still have a home or CDBG loan secured against the property, or units that are occupied by home tenant-based rental assistance tenants. So we are focused on rental projects, but wanted to provide this additional information for you guys, as I know that a lot of you deal with a lot of different, more than just the projects and properties that are within our portfolio. So so just so you're aware of that. So which units does the eviction moratorium apply to? And within the CARES Act, it kind of approaches this in two different ways. So for home assisted units, it applies to home assisted units that are within rental or homeowner properties that are currently within their period of affordability. However, if a property has a home or a CDBG loan that's currently, secured against the property, then all residential units in those properties are considered, are subject to this moratorium. Now, how we come out of the eviction moratorium is going to look different depending upon if you're working with a home assisted unit or one that is not home assisted. And so we'll get to that, but wanted to just identify. So again, wanted to just make this kind of clear. We are all, we that are presenting, we are assuming that you represent a property that got federal funding from Metro, and your property is still in its period of affordability. And essentially, as a result of that, all the residential units within your property are going to be subject to the CARES Act eviction moratorium. So what does the eviction moratorium mean? It means that between March 27th through July 24th, so at this point we have about just under 30 days left of the moratorium, that owners or managers cannot initiate eviction for non-payment of rent or other fees by filing in court, or charge fees or penalties to tenants due to non-payment of rent. What you all can do is you can accrue monthly rent and fees, except those that are related to non-payment of rent, and charge them after the 120-day moratorium. And you may still evict tenants under other good causes other than non-payment of rent. So we know that not all evictions are related to just people not paying their rent. And so this moratorium provides protections just for those that are unable to pay rent at this time. So if a tenant was not provided an eviction notice for non-payment of rent before July 27th of this year, then a notice cannot be issued until after March 27th this year, can't be issued until after July 24th of this year. Just a reminder, under the home program, if a tenant is residing in a home assisted unit, they must receive a 30-day written notice prior to terminating tenancy. And we're going to talk a little bit more in depth about that. But when I talked about having this eviction moratorium be applicable to your entire property, but how we come out of this, what that looks like, it's going to look a little bit different based upon if you have someone that was not able to pay rent that's residing in a home assisted unit versus someone that is residing in a non-home assisted unit. Now, your project might have other funding sources that may have their own restrictions as well on that other unit. So just a caveat for you all, we're talking about home in this particular presentation, and that's what our focus is with regards to that. So what does the home eviction process look like? So under the CARES Act eviction moratorium, we wanted to kind of lay out what that's going to look like for those that are residing within a home assisted unit. So if a tenant in a home assisted unit continues to be delinquent, on rent payments, then a 30-day notice can be given on July 25th. That 30-day written notice has to specify the grounds for the termination, and the eviction has to occur under home. It says that tenants can only be evicted if there is good cause. So I defined what good cause is here. Repeated violations of the lease terms, serious violation of state, local, or federal law. So if there is good cause and the tenant hasn't remediated the issue within the notification period of that 30 days, then you may file that eviction after the 30-day period expires. So I know that this, I wanted to just go over this because, again, I was looking out, this is part of their tenant protections. And I know that this might be a little bit challenging coming from an owner or a manager perspective, but wanted to just identify this is a protection tenants that are residing in home assisted units. So again, wanted to go over the home eviction process, what under normal circumstances, who knows what normal will look like, but when we get there, but essentially under normal circumstances, again, the period, it looks pretty darn similar, but tenant has to be provided with that 30-day written notice to terminate tenancy, must specify the grounds for the termination. They have to, you can only evict if there is good cause, again, define good cause, repeated violations, serious violations, or violations of federal, state, or local law. And then the tenant is provided that 30-day window to remediate any of the issues. And then if they are unable to do so, then eviction can be filed after that 30-day period. So layered on top of this federal CARES Act is the state of Kentucky has their own eviction suspension law. And so some of you also might be familiar with the state law that addresses evictions. So the governor, under his executive order in March, at the end of March, indicated that they were going to cease enforcement of eviction orders. The Kentucky State Supreme Court issued a statement in the end of April stated that eviction filings will be accepted 30 days after the expiration of their order, and that order is effective through May 31st. So what that essentially says at this point is that under state law, evictions may commence July 1. However, if you have the layered between CARES and Kentucky, CARES is going to supersede that. And so evictions may not commence until the end of July 24th. Now, if you've been keeping a pulse on this, which I'm sure you all have, I just read yesterday that the state of Indiana is continuing their eviction moratorium for their state. I have not heard at this point if any changes are being made to Kentucky, but if we see changes occur that are going to be effective, whether it's coming from federal or from the state, we'll make sure to keep you all informed, because we do know that this is going to be will impact your property. Again,
Stephanie,
yes.
Stephanie, this is Marilyn. I just want to let everybody know that there is a internal eviction prevention task force out there that is working to solve eviction problems. But they sent a letter to the governor last week with about 60 sign-ons asking the governor to extend it. And the city of Louisville is asking the governor to extend it. So I would not be surprised if that does not happen.
So there you go. So as we get more information about that, we will most certainly keep you all informed. So the state is essentially the same kind of thing with the federal. Renters are not relieved of their obligation to pay rent. They still have to pay rent. Owners can still evict if the cases involve dangerous criminal activity, serious health or public safety concerns. However, there has to be a waiver that's requested, and I included the link for that. So just trying to put this all together for you guys. So again, the state says evictions can start at this point on July 1st. However, you got federal funding from local metro government, and or your property is still within its period of affordability. So you cannot start evictions until July 25th for non-home assisted units. For home assisted units, on July 25th, you can give them written notice that about filing an eviction on them. Again, it's a 30-day written notice. So the earliest an eviction may be filed is in August 25th, assuming that the 30-day notice was given July 25th. So again, we know that this is we're kind of coming into the time where we're potentially easing out of some of these restrictions. And like Marilyn talked about, we are anticipating seeing something coming from the state or federal or both on potentially extending these restrictions. And as soon as we know that information, we will share that with you. Now, we know that having eviction moratoriums is most certainly challenging, not on it's beneficial for the tenants, and everyone is really struggling at this point on a variety of different levels. But we also understand that this is also a struggle for owners and managers as well. That you all have to pay the bills too for the property. And you know that when you have tenants that are delinquent due to their unforeseen circumstances, it makes it harder on you all. So we wanted to just identify that there are a couple of programs that are out there to provide assistance to your tenants, and in turn to hopefully provide some assistance to you guys as the owners of these properties, to make sure that you guys are still continuing to run in the black during this time. So the One Louisville COVID-19 Response Fund, that is still accepting appointments at this time. Eligible households are able to receive up to $1,000 to assist with rent, childcare, food, transportation, and utilities. So if you have someone that is coming to you and saying that they're having a difficult time paying their rent, and it's due to COVID-19, please share these programs with them. Also, the Team Kentucky Fund, which is a state program, also provides eligible households vouchers up to $1,000 to assist with rent or mortgage payment, food, and utilities. There is another new program that is under consideration by Louisville Metro Council, and hopefully will be approved by them. But that it is an eviction prevention program that is going to be managed within the Office of Housing within Louisville Metro. You heard Marilyn Harris talking. She's the director of that program, and is spearheading this program, for the Office of Housing. But that proposed plan provides rental assistance for 3 months. And what's unique about that program is that it will provide a tenant-based application, which is what the other two are. A tenant has to be proactive and apply for the assistance. But there is also a process in which owners or managers of federally subsidized units can apply directly on behalf of their tenants. And so I felt like that could be a really great benefit for everyone on this call, because if you are seeing some financial challenges with your properties relating to, inability by tenants to pay their rents, you hopefully, if this is a program is approved, will have the ability to kind of take matters into your own hands. So hopefully that goes forward and it's able to provide you all with some support.
Hey, Stephanie, I'm sorry. It's Marilyn. I'm sorry. I didn't think about this. If you go back to the last slide, it says 3 months worth of rental assistance. And it's actually, it will provide April, May, June, and then July's. So it could provide, the intention of the program is to bring the tenants current. So if they owe for 4 months, then it would be for 4 months. So realize we started proposing this in June, but now we're facing July's rent. So if they are delinquent for July and April, May, and June, it could very well bring them completely whole.
Which is wonderful.
I don't know if you want me to add, but there are some strings attached, which is there's always strings attached, and that the main string is that if you receive assistance from this program for tenants, you have to certify that you will not evict them for an additional 60 days. So regardless of whether they pay their rent or not. So you just need to make sure everybody understands that there are some strings attached, and the big string is that you have to waive all fines, fees, and late charges, and you have to agree not to evict them for the next 60 days. So, sorry.
No, that's great. Thank you, Marilyn. I appreciate it. So, we know that the managers and the owners that all are really they've been the front line on a lot of this stuff. And, they see these challenges with their tenants most certainly every day. And so hopefully some of these programs will be mutually beneficial for you all. So a lot of information went through there, but any questions at this point?
Stephanie, I'm not seeing any questions in the chat bar.
Okay, perfect. Well, then we'll keep going. Okay, so since we talked a little bit about the evictions, we wanted to just touch briefly a bit on tenant protections and lease requirements, because the eviction kind of awful. So tenant protections within the home regulations are prohibit certain clauses within a lease. And so this list, not going to read it to you, but this list is a list of the things that are prohibited to be within a lease to protect the tenant. There are additionally some lease requirements that must be included within your lease. You have to have a lease for 12 months unless it's mutually agreed upon between the owner and the tenant. Depending upon what stage the project is in, then the lease of the project is going to be used, it has to be approved by the Office of Housing or the Division of Compliance and Administration. So in theory, what a lot of this typically looks like is that a template will be provided as part of the development stage, which is the Office of Housing. And so that is approved during that. However, if you have a change in manager and they're going to use a different lease, or you're revamping everything, whatever, then you will want to make sure, and you're within your period of affordability, before you start that and start to use that lease, please send that on to the division, to Jake, to review. This is, great for you all, because we'll make sure that, it's compliant with home before you start using it. And it's another set of eyes. So what do you got to lose there? Again, talks about the 30-day written notice. It can only terminate for good cause. You have to permit required inspections, clearly state the terms for rent increases. If your property is built prior to 1978, then you have to talk about the lead-based paint notification requirements. You need to make sure that you're including the Equal Housing Opportunity logo, the little house on your lease and all of your property documents, and or including the Fair Housing, Equal Housing Opportunity clause. And then we also want to make sure that we're including the clause and or the lease attachment for the Violence Against Women Act, or VAWA. So any questions about those?
I'm still not seeing any questions in the chat bar. And just to let everybody know, if you're not familiar with WebEx, the chat feature looks like a little speaking bubble. It's kind of down towards the bottom of your screen. So if you do have any questions throughout this meeting, you can use that to send your question directly to me.
Perfect. Okay. Inspections. So we wanted to also touch on CARES Act and the inspections. Like I talked about in the beginning of the presentation, the CARES Act not only talked about the eviction moratorium, but it provided some additional flexibilities, I guess, to participate in jurisdictions that are in charge of the home program in response to COVID-19. So what that in turn means locally is that as of this time, as of the date of this training, all property inspections for home assisted properties are on hold. Once inspections commence, we will notify Jake, will notify everyone that we will we'll be restarting property inspections and providing some more detail. Kind of how we envision this kind of looking is that we know that there's going to be a backlog of properties that are going to need inspections. So essentially the ones that did not get inspected when the pandemic started, and then also ones that are due for their annual inspection. So we just ask that you work with us, work with the division to respond to all requests and provide all documents within a timely fashion, because we, again, we just know we will have this large amount of units that needs to get inspected, and that's going to be a larger weight to carry. So if your property is due for an inspection, you will be notified as you have been in the past. You'll be asked to identify the home assisted units in the property at the time the notification is provided. We know that many of the properties within our portfolio have floating home units. So what a property might report on their last annual compliance reports as to what their home assisted units are may change when we are actually coming out and inspecting. So that's why we're asking again for what those home assisted units are. And we're just going to ask for you all to get that information back to us within 7 days from you receiving that. Again, if you're due for the inspection, you'll be notified. We ask for the 7 days. The Office of Housing Rehab Specialist will contact you to schedule the inspection. Again, please remember that you have to provide at least 48 hours notice of an inspection for your tenants. If your property was not inspected due to the COVID-19 suspension and requires an annual inspection for this upcoming Metro fiscal year, which is fiscal year 2021, what we will be doing is doing one inspection with a larger sample size. So instead of coming out twice, we will be doing one inspection, larger sample size. So what does that look like right now? The sample size is dependent upon the number of home assisted units. So if you're less than 4, it's all of the home assisted units. And then if it's greater than 4, then it's 20% of the total unit count. At this point, the division has not determined what that sample size is going to be and how we're going to determine what that sample size is. We're kind of waiting to see when we're going to restart inspections and what our backlog looks like and what we have to complete for the annual inspections when we restart, and the time frame that we have to complete it. So once we get that information, we will most that all out to you so you're aware. But what it may mean is that we might be inspecting home assisted units and non-home assisted units within an inspection, because just depending upon how large your property is. So this is the inspection frequency. If your development has 26 or more units, you are due for an inspection every single year. And then depending on if you have a smaller property, it's either once every 3 years or once every 2 years. So just wanted to point that out for you all. Any questions regarding that?
Definitely, I don't have any questions yet.
Wonderful. Okay, well then I am going to turn out everything over to Jake, and who's going to be going over what annual compliance reporting is going to look like this year. And yeah, so take it away.
All right, everybody. We're going to talk a little bit about what I'm looking for with your compliance documents and when they're all due through the for the upcoming compliance reviews. There we go. Okay, so everything is due by July 31st. All of your documents for annual review are due the end of next month. We will need your unit compliance report, often referred to as your UCR. We'll need your compliance certification, your owner manager information, your affirmative fair housing marketing plan, if applicable, and then if you plan to increase the rent or change your utility allowances, then we'll also need forms that are provided for those. And then we will need, if applicable, your utility schedule model, properties audited, 2019 audited financials, 2020 operating budget, proof of insurance, your lease template, just that way we can review it over again, and your current rent roll for all units. All of these are available at louisvilleky.gov/government/housing. Down here at the bottom of the page, you can see where it's highlighted in yellow, compliance and home, CDBG, and NSP. So click that, and it will bring you to this page. And this gives you all of the forms that you need to download. Your unit compliance report, your compliance certification, owner manager information, and your fair housing marketing. Those you can download from the website, and then you'll also need to scan in and upload your financials and allowance and insurance and leasing like that. All of these.
Jake, I just wanted to jump in. I checked the website this morning. The forms haven't been updated and put up on the website yet. So when we make sure that all those things have been, the forms for this year, they still have the forms from last year. We made some revisions, so we want to make sure you guys get the right forms that you're filling out. So once we know that those are ready to go, we'll let you know.
Yeah, and those should be ready in the next day or two. All the forms are completed. We just need to get everything uploaded to the website. If you happen to pull up a form that doesn't say doesn't have the year 2020 on it, it's probably not the right form. Just keep that in mind. So this is what it looks like. This is at the bottom of that same page, and this is what it looks like for you to submit your information. You'll select your project. You'll upload your unit compliance report and all of the rest of the information. And then at the bottom, you'll put your name and your email and hit submit, and that will send it all to me. So as you can see, we've got all of your projects listed here in the drop down. If by chance you're going through and you don't find your project listed, send me an email. We'll figure out how to get that straightened out. But it should be everybody on there. This is what your compliance certification is going to look like. There are areas for you to fill all of this out. There's no real reason for you to print it out and do it by hand. You can just enter your information here onto the Word document and then save it and send it to me that way. There, like I said, no reason to actually have a paper copy of this. Your owner property information, pretty straightforward. It's how we contact you. And then onto the unit compliance report. So the unit compliance report is an Excel spreadsheet, and there are 5 tabs on there. The first tab, possibly the most important tab, is the instructions. It details everything that you need to know to fill out this spreadsheet properly. Now, of course, if you have a question, I'm here to answer it. So, feel free to ask. But most questions should be answered on tab 1. Tabs 2 and 3 address your utility allowances. With tabs 2 and 3, depending on when your project was funded, if it was funded before August 23rd of 2013, then you'll use utility allowance tab 2. If it was funded after August 23rd of 2013, or utilizes other utility allowances, then you'll use tab 3. If the cell is yellow, then you must fill it out. One of the things that I notice in these utility screens is that often when it's owner provided utilities, these tabs tend to get missed. I can't tell that you're the one paying the utilities unless you mark that you're the one paying utilities. So go through and fill out all of the appropriate utilities that are being used in order to get the correct utility allowances. And then if your project has LIHTC or project-based Section 8, then there are places for you to fill out the applicable rent limits. You will have to put in the income certification dates determined by home rent and income limits. You cannot change the rent limits until the effective dates. The reporting period is from July 1st, 2019 to June 30th, 2020, which means the income certification for the tenant should have been completed during this compliance period. So if you have any home units that you haven't certified their income this year, you should probably get on that as quickly as possible so that it all falls into proper compliance. And then you want to list only the residents living in home units as of June 30th. So if you have move-outs or move-ins during the compliance period, list only the tenant that's living at the property on June 30th. So this is what the UCR looks like. You can see where you enter the LIHTC rent limits or the project-based Section 8 rent limits. And so you will enter those if applicable. And then You can see here we've also noted the utility allowance tab, which you need to select the proper information in tab 2 or tab 3 first before that will properly populate. So, utility allowances, because this stuff sometimes gets a little confusing. If the tenant pays the utilities, then you need to fill out the utility allowance stuff. You will need to mark that the owner pays the utilities if that's the case. It's just there's a lot less going on if that's the case. So the maximum net rent includes the utility allowance. So it's the rent limit minus the utility allowance, and that's the maximum net rent. In general, properties cannot charge more than the maximum net rent. The utility allowance for a property must be established and updated annually. Utility allowances are reviewed by the Department of Compliance Administration as part of the UCR, Unit Compliance Report. So we look over those every year. And in general, properties are to use the utility schedule as published by Louisville Metro Housing Authority unless they receive a commitment of home funds after August 23rd of 2013. Projects receiving a commitment of home funds on or after August 23rd of 2013 must use the HUD Utility Schedule Model, HUSM. You can't use the FMHA's utility schedule. And the properties must submit their utility allowance for approval with the unit compliance report. So we need to see that utility allowance so that we can approve it. We also accept the usage of utility allowance, which has been approved by separate funding agency like Kentucky Housing Corporation. And the property must, if that is the case, you must submit that information to us so that we can approve it. If you were funded after August 23rd of 2013, you'll use this utility schedule model. And it can be found at this website, which is on the HUD website. And it's going to give you a breakdown of what you need to enter. You'll select your zip code for the property. You'll select your unit types and bedroom. And then you'll select who pays what in the actual allowance section. And, you know, so if it's gas heating or electric heating, you'll select whichever one is appropriate for the unit. You know, very, very rarely do you see heating that is bottled gas here in Jefferson County. It's just not something a lot of people do. So if you're selecting one of these fuel oil or bottled gas, like maybe you should pause a minute to make sure that that's what you're actually supposed to be choosing, because most people here in Jefferson County use natural gas and electricity that come from LG&E. So you'll select what the unit uses to heat their water, to run their air conditioner, and the like. And then when you move down the page, it gives you an area to put in the actual rates. It gives you, you put in the utility, you put in the name, you select the months that it's eligible for, because sometimes LG&E has different rates in the summer than in the winter. So you have to pay attention to that. And then you put in the amount per kilowatt hour for the utility. and you just go down this list, filling it all out. And LG&E doesn't seem to do like utility blocks to where after so many kilowatt hours, you get charged a different rate. So for the most part, we'll just be filling in the first block information, and you won't move on down these other to these other blocks. But if you find yourself in a situation where you do, then you would just go on down the list. Once you get all of the utility information filled out on this, you select the next page, and it gives you this lovely information, which is your utility allowance information based on the HUD Utility Schedule Model. You'll take all of this information, and so you'll want to, if you're using this, you'll want to screenshot each of these things so that you can show it to me. Unfortunately, this tool doesn't give me the ability to see the information that you put in. It just gives us this final answer. So I do need you to show me these screens as well as this screen here in order to know how you got these numbers when I'm trying to approve your utility schedule. There are forms that you'll fill out in order to get this approved, which are available on our website. Again, it's a Word document that you can simply download and fill out, and then you'll attach your source documentation, which will either be a utility allowance from somebody like Kentucky Housing Corporation to show me that that's what you're using, or the utility schedule model, or whatever supporting documentation that is necessary to show me why you're making this change in the utility or why you're using this utility. And then you'll email all of that to me, and we will give it a look over and see if we can get it approved. With rents, rent limits are the maximum rent that can be charged to an income-eligible tenant residing in an assisted unit. For this training, we're focusing on the home rent limits because sometimes when you're using other funding sources as well, they layer and interact with each other. But we're going to focus on the home limits. Not all of the units in your property may be home units. Some units have multiple funding sources, resulting in the layering of rent requirements. And rent increases for home units, you must get those approved 60 days before they're effective. And you must give the tenant 30 full days of notice, and it must be in writing, both to get the approval from us and to notify the tenant. This is what the rental increase approval form looks like. It's pretty similar to the utility allowance increase form. You'll download it, fill out all of the pertinent information, and then submit it to me, and we can see what we can do to get it approved again. And yeah, it's all pretty simple and straightforward. These are our 2019 home income limits or home rent limits. And so these should be listed on the UCR for you to see. And these will be the ones that become effective July 1st of 2020. And this change in rent limits is one of the big reasons that we want you to get everybody income certified before July 1st of 2020. Because if you get them income recertified after July 1st of 2020, then it's going to want to use these new rent limits, which are not the ones we're trying to use. We're using the 19 rent limits because this was for the fiscal year 1920, and all of your compliance information will be before, based on information before July 1st of 2020. These are our income limits for 2019, and to be a home assistance unit, the resident has to be at or below 80% of the area median income. And this breaks it down up to 8 people in the household. High home units use anybody who's 80% or lower. Low home units use anybody who's 50% or lower of the income limits. So these, and you can see how they're highlighted here. These rent limits are very important to who can move into your units. And these will be the rent limits for, or the income limits for 2020 going forward after July 1st. Are there, I believe there were some questions.
Oh, I was just going to chime in. Can you hear me? Yeah. I was just going to chime in because when we do our annual compliance reviews, we're looking backwards. And so what just when HUD issued their update to the income and rents this year, it just sort of worked out in our favor because they're effective July 1. And so those 2019 rent limits and income limits, that's essentially effective for the whole compliance year that we're reviewing this year. So they were effective starting July or June 28th of 2019, all the way through June 30 of 2020. So again, that just has lined up really nicely for us for our compliance year review. So we only have one set of income limits, one set of rent limits that we're going to be looking for compliance with. As we move into the new fiscal year for Metro, and as we move into July, those income limits and rent limits have changed. And so if you intend on making any type of changes to your rents, you can review those and send those along with your annual compliance documents. So.
Stephanie and Jake, we do have a question in the chat bar. Is the wage match required at MI and AR or just MI?
Say that again, I'm sorry.
Is the wage match required at MI and AR or just MI? And that's from Lisa. I can unmute Lisa if you need more her to explain that a little bit.
Yeah, you could.
Hi, thank you for allowing me to ask the question. We are working with a new client, and we had heard in another state that the wage match verification that goes in with the certifications is just required at move-in and not at the annual certification. And I'm just wondering if Kentucky has the same requirement or if we do use the wage match form for every certification.
Yeah, so under home, you are required to do an income verification with source documentation as part of the initial move-in. At recertification, you are allowed to do a self-certification. So you don't have to actually go and obtain all of the source documentation, third-party verification that you would with an initial move-in. Now, if you have layered financing and have multiple players in your property, that might be different depending upon who is funding your project. But under home, you are allowed to use that self-certification or an income certification from another governmental agency like LMHA. That being said, within your the project's period of affordability, every 6th year, everyone that's residing within a home assisted unit must have source documentation and do a whole full-blown income verification again. So if you have someone that moves in, next year is your 6th year, you will do an income verification with source documentation with that third-party verification 2 years in a row, just because of how things happened. So hopefully that answers your question. If not, let us know.
All right, we have another question from Linda. She's asking about what to do when audits are performed late.
Oh, well, your property audits are performed late? Yeah. Yeah, so that's a good, great question. If you have drafts of your audits that are not yet approved and you are comfortable sharing those with, when you them, if they say draft on them, that's fine. You're welcome to submit those. If not, and you don't have those drafts available, or you're not able to share them with us yet, then my recommendation is reach out to Jake, let him know that you have not gotten final, you haven't finished the property's audits yet. And let him know when you would anticipate the audits being finalized. And we most likely have the one that you submitted the year previously, so it's not like we would need that one, but we would just allow you to not submit that piece of information, and then we'll be reaching back out to you to request it when we would anticipate it to be done.
All right, and we don't have any more questions in the chat box at this time.
Awesome.
All right. So moving on. Maybe. So this is all of our contact information for anything that you may need. You can reach out to any one of us. I specifically focus on your projects, so I'm probably the best place for you to start asking questions. So, send me an email, but if you need to reach out to one of the others, feel free to. That's Jake Greenwell, that's me, or Corey Goad, or Stephanie Burdick, or Justin Robinson. And these are some places where you can get more information. The HUD Exchange info, hudexchange.info. And that goes over, and then there's the compliance guide that we'll be sending out. And the Louisville Metro or louisvilleky.gov/government/housing is where all of our documents are saved for you to download and submit. Is there anything else anybody needs to add, or? Steph, you're muted. There we go.
I'm sorry. Thank you. Thank you, Justin. I don't have anything else really to add except for thank you all for participating in this, training. Thank you all for being flexible, and thank you for the work that you all are doing in our communities. Again, if you have specific questions, feel free to reach out to Jake. And if if we see the need for training around a specific topic because we weren't able to get together for a day-long training and covering a lot of topics, and getting a lot of questions, we may choose to kind of do this format again to address questions or a specific topic that we're seeing a lot of questions about. And so just stay tuned and stay watch your emails for that.
Well, thank you. And I want to say thank you, everybody, for participating as well. Everybody has the same goal of helping people stay in housing and stay safe. And we're all here to work towards that goal, to help you work towards that goal. So if you need anything from any of us, don't hesitate to reach out.
Thank you, Stephanie, and thank you, Jake.
Alrighty. Well, with that, I think we'll give you back your day. And again, thanks and have a great one.
Thank you all.
Thanks, everyone.